24-002-333 James D'Angelo versus Ronald Thomas and Biddle Storage. Appearances, please.
Good morning, Your Honor. Joseph Grant on behalf of the plaintiff.
Good morning, Your Honor. Scott Ossemacher on behalf of Thomas and Biddle Storage.
Okay, Mr. Grund, this is your motion. Go right ahead.
Your Honor, I have two motions, and first I would like to clear up a point. I filed these motions on April 22nd, 2025. I received an email objection on May 8th stating that my briefs were too long. So on May 8th, I filed the first amended motion for each motion, on the complaint and the counter complaint. That's more than 36 days in advance. He's saying I'm gaming the system. I didn't do anything but bring it down to the page limit requirements. And Mr. Ossemacher, he filed his response late. He filed it on Monday to one motion. He never filed a response to the other motion. So I assume he filed an answer to the counter complaint motion. So my motion on my complaint is unopposed as far as I can tell. Because actually on both of them, because neither was filed timely and one wasn't even answered. So I think there's a problem there. And I can proceed. Which motion would you like to hear first after that?
You know what? I say we argue the motion on the complaint first and then on the counter complaint second.
Okay. Your Honor, essentially this dispute arises out of a parcel of property down on Biddle Avenue in Wyandotte. Mr. D'Angelo's company, Biddle Storage, owns property on either side of the D'Angelo property. Whether it's, and it could have been in a separate company, but in any case, right now it's Biddle Storage. He testified owns it. Back in 2021, they were having negotiations regarding sale of the property to Mr. Thomas or his corporation. And they never agreed to it. After that, on August 9th, 2021, Mr. Thomas filed a claim of interest in the property, a contract to purchase real property in Wayne County, showing a proposed deed and saying that he was buying it, but the legal description was in his company's name. And for more than 2 years, he never notified my client that he even liened the property or had a claim of interest in it. He never recorded Thomas never recorded a proof of service. He just recently, yesterday, released the lien or the contract of the claim. The lien on the property, released it yesterday, but even that's been 4 years since he put it on the property, and he wants to say he's removing his claims, but he still has a notice of lis pendens on the property that's there that he filed. Defendant admits in no uncertain terms that he's not the purported owner of the property. He states specifically in an email on October 23rd, which is attached as Exhibit D, as a related note of caution, per our email exchange, property records and the draft deed you provided me, you are personally the seller and an LLC of mine is the purchaser. So he doesn't own the property. If there's anybody that would do it, it would be Biddle Storage. It's not Mr. Thomas. So he puts a lien on a property which he doesn't own and he has no claim to, by his own admission. So he's
recording in progress.
Sorry, go ahead.
So he's put a lien on a property that he's not making, that his company may own, but he doesn't, or making claim to. And MCLA 565.108 prohibits a party from using the privilege of filing notice for the sole purpose of slandering the same. And if it's proven that, he's entitled to actual attorney fees. Mr. Thomas readily admits he has no contract with Mr. D'Angelo, but he did it just out of spite. He filed an invalid lien and he knew it was invalid.
Okay, go ahead, Mr. Ossemacher.
Thank you, Your Honor. I think
I wasn't done.
Oh, I thought you were. Go ahead, Mr. Grun.
Oh. The lien is incorrect. He shouldn't have done it. In his October 21st, 23rd correspondence, he goes on to state that, where was it? And as a related note, he trespassed on the property. Not only did he take the property, he fenced in the property. He took the property. There's pictures attached to my motion where he fenced it in and took the property. So he's trespassing. So he's trespassing. He put an income pursuant to 56525. He has to give a proof of service and record a proof of service. He hasn't done that. So there's an improper encumbrance on the property. He can't give a fair accounting of the facts because he's not the party that even by his own admission is buying it. It was more than 2 years. If they provide it without unlawful cause, pursuant to MCLA 62907A, actual attorney fees are entitled. And that's October 23rd correspondence. He further goes on and states in no uncertain terms that he's content to leaving the purported purchase agreement and related register of deeds filing in place for many years, just like plaintiff has done to Thomas's detriment. So he's going out of his way to say, look, I'm just taking your property and too bad. So he has malice. I would ask that you grant my motion for summary disposition. He set aside his affidavit now, but there's still a notice of lispendence on it. The fencing is still there. Set this matter for damages in order for what else is fair and just.
Okay. Thank you. Go ahead, Mr. Osmacher.
Thank you, Your Honor. So our response to plaintiff's summary disposition addresses all issues. From my review of my records, an initial motion was filed, and the documents that we received only indicated a request for affirmative relief on certain claims. The subsequent amended motion appeared, at least in our review, to sought address in summary disposition as to both affirmative claims and counterclaims. Regardless, our response addresses all issues before the court. As a matter of housekeeping, earlier this week, immediately after filing the response to motion for summary disposition, the response was timely filed on Friday. Unfortunately, it was kicked back due to exhibits that did not meet the formatting requirements. That was immediately cured, and a revised response was submitted on Monday along with the judge's copy. We are willing, as indicated, it's in our response, it's no longer tenable for Mr. Thomas to continue to seek specific performance. Accordingly, he's released his discharge. We sought a voluntary dismissal with prejudice as to our claims for quiet title, declaratory action, and our request for specific relief as asserted in the complaint. Mr. Gren refused to stipulate to that dismissal with prejudice, insisting on language that was not necessary and not in accordance with the facts. As soon as those claims are dismissed, we will, of course, remove the notice of lispendence. These facts are continuing to develop, and Mr. Thomas is in the process of getting the fence removed from the property, but it does take some time, and our client is committed to removing the fence in a reasonably prompt, business-like manner. Getting into the heart of the dispute, in our view, the proper view of the elements of the case is to deal with a breach of contract claim first. There's no dispute that a contract was formed between the parties. Breach of contract claim requires the existence of a contract, breach, and damages. With respect to Thomas's claims, all those elements are satisfied here. Thomas and Mr. D'Angelo, there was a meeting of the minds as to all the essential terms of the contract. They sale of the property. They knew which property they were talking about and subsequently affirmed that understanding in written documents prepared by D'Angelo. They had the price, all the necessary terms were met. And accordingly, from our perspective, and our view of the facts, Thomas should be entitled to summary disposition in his favor on the existence of whether a breach of contract claim exists. Best case scenario for Mr. D'Angelo is that whether or not there was a meeting of the minds, goes to a jury. It's simply not a best case scenario is that this is whether or not there was a meeting of the minds needs to go to a jury. Moving along to the issue of the statute of frauds, because this was a purchase agreement for the sale of land, it has to satisfy the written requirements. Those requirements were met here. The written communications between the parties, along with the associated attachments, clearly satisfy all of the elements necessary for the statute of frauds. They are in writing. They clearly identify the land. The parties were in agreement as to the nature of the deed that was to be transferred back and forth. And with respect to Thomas's really only, or D'Angelo's only real defense to try and get around this is, there was the signature waiver requirement, which is clearly just a post hoc justification for his attempt to get out of the binding a deal between the parties. As set forth in the case law attached to my motion, there isn't really anything in Michigan that is directly on point, but other courts in other states have generally found that the existence of one of these purported waivers is one factor that the court can consider as to whether or not an agreement was formed, things like that. Furthermore, as set forth in the agreement, the waiver indicates, except for express statement to the contrary, it was in our client's, Mr. Thomas's view that his statement that he accepted the offer was a sufficient statement to overcome that waiver. Moving on to to D'Angelo's affirmative claims for slander of title. He simply cannot meet the elements here. The claim requires, 3 points: falsity, malice, and special damages. First of all, he can't prove falsity because what was filed was a true and accurate representation of Mr. Thomas's interest in the subject property on behalf of his LLC. That was a true and accurate. There was a binding agreement, and he had every right to file that. Furthermore, even if the court were to disagree with Mr. Thomas's and our conclusion and legal arguments here, the fact that he filed that and the court subsequently disagreed with his opinion cannot be evidence of malice. The only other evidence of malice that plaintiff has asserted is a statement contained in a letter that is simply taken out of context, as clarified by the affidavit by Mr. Thomas submitted along with our response. That was not the statement contained in that letter is taken out of context. This was never filed with malice. This was filed with the intent that Mr. Thomas could protect his interest in the property while he sought specific performance. Again, once it became untenable for him to maintain that claim, he immediately discharged his interest, just like he would have if the court had found that there was no binding agreement between the parties. Accordingly, he cannot show either falsity or malice. And even if the court were to consider the statements contained in the years later email as evidence of malice, that would ultimately, between that and the affidavit, create a question of fact that would need to go to a jury. I have nothing further unless you have any questions.
Mr. Grant, any response?
Are we still on the first motion? Because he argued both motions and I never made it to my second motion.
Well, I mean, they're kind of one and the same. It was the motion for summary on your complaint and the motion for summary on the counter complaint, but he only responded to one of them in written form. It's my understanding, but he did argue both of them. So take it any way you want, Mr. Grund. Just go ahead.
Well, then I'll argue my second motion.
Yeah.
Your Honor, there's big block letters, and it's kind of neither the information in this block, the type name of the sender, nor anything else in this message is intended to constitute an electronic signature unless a specific statement to the contrary is included in the message. Michigan law is quite clear on that. In Little v. Ken, where language of a legal instrument is plain and unambiguous, it is being enforced as written and no further inquiry is permitted. I'm using Michigan law, I'm using Supreme Court law, I'm using published law. Mr. Ossenmacher, he's in another state. He's not even using Michigan law, and he says, well, it's the same thing. It's not. He's using parole evidence to contradict the terms of his express language. In RE Lex Estate 289 Mich. 574, you can't contradict the terms of a document by parole evidence. He's contradicting it. And my client does not agree that they had a contract. If you look at all the documents, every time the emails, every time there's another email, the terms of the agreement change. Even who's buying it. There's a standing problem in this matter, Your Honor. The counterclaim is filed by Mr. Thomas. Mr. Thomas in his emails and in his letter of the 23rd states that Biddle Storage is the owner of the property, and Biddle Storage is the purchaser of it, not Ron Thomas. That's standing. That's a problem. That's an admission against interest, and that goes to the heart of the matter. Who is the party purchasing it? It's not clear. If it is, it's Biddle Storage, if there is, but they never agreed to anything. He didn't even meet the deadlines. He said, I want to close by the end of July. He didn't. The taxes were an issue. There's all kinds of issues. The parties aren't even correct. So there was preliminary negotiations. There wasn't a whole bunch more. And for his property, the reason why he's backing out now is Mr. Thomas's claim is untenable. And it's untenable because he has unclean hands. He has unclean hands because he filed the lien. He never gave notice to anybody that he even filed the lien. Even there's equitable estoppel. That's in this case. Whereas a party by representation or admission negligently induces another party to believe facts. Mr. D'Angelo relied on the facts that they were negotiating, and now he'll be prejudiced. That's West American versus Meridian Insurance, 583 Northwest 2nd, 548. I'm using all published Michigan opinions, and I rely on the Michigan opinions, not other courts. I can go into unclean hands. It's tortious, it's overreaching, and the reason why I didn't sign his order of dismissal, because on my order it said he's dismissing it because his claims are without merit, and he just wants to dismiss them and elect his remedies now at the end of the day. I want this judge to rule and say, look, there is no valid claim. And that's why I didn't sign it. Everything he's doing, Mr. Ossenmacher, it's at the last minute. He could have released everything ahead of time. It's only untenable because he does have unclean hands and he doesn't qualify under case law for relief in this matter. And I ask that his claim be dismissed and all my claims be granted.
Okay. All right. Based on what was presented to the court finds that there was no purchase agreement. There was no compliance under MCL 565.25. There was slander of title. He is entitled to attorney's fees and costs in both bringing the action and defending the counterclaim. Counterclaim is dismissed. Motion for SD is granted with respect to Mr. D'Angelo's claims. I'm going to set this for a hearing on attorney's fees and costs. July 18th at 1:30. Any exhibits need to be exchanged no later than July 11th. Put that in the order, Mr. Grund.
Your Honor, is that a Zoom hearing or in-person hearing?
It's going to be Zoom.
Thank you, Your Honor.
Thank you.
Your Honor, I have one more question.
Yep.
Regarding, they gave us an order for mediation or facilitation.
It's done. You don't have to go to mediation. All right.
Thank you, Your Honor.
you.